I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive.
Good evening, ladies and gentlemen, degenerate sleuths of the night. We gather to boldly go where others have refused. Welcome to the DT show, you salty mofos.
A man accused of killing 4 college students is behind bars, and he has ties to northeastern and central Pennsylvania. State police say 28-year-old Bryan Kohberger was arrested this morning in a home in Chestnut Hill Township.
I can't find any case law that would support that idea. That somehow a warrant would be needed for DNA left at a crime scene.
We are expecting to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
So, the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
So, get your popcorn ready and your choice of drink. Get your butt on your seat. Like, comment, and subscribe for a treat. Here we go. It's time for the show. The Drunk Turkey Show.
What is up, you salty mofos? Welcome back to the show. There's a pretrial hearing that's about to happen in the next 20 so minutes or so. Now, I'm not sure if because it's on 2 things, right? It's going to be on the continuance, which is public, and it's also going to be on the alternate perpetrators if Hitler is going to go ahead and allow that in. That part is sealed. I don't know if that's already gone down. I haven't seen anything on the Twitterverse or Xverse, whatever you want to call it nowadays. I haven't seen anything there that says that hearing happened earlier. I know that Brian Enton went live on X yesterday and mentioned that there was a hearing today at 9 a.m. local time to Boise. So don't know. I don't know. Please hit the like button, hit the subscribe button, ring that notification bell. We're going to watch this pretrial hearing as soon as it goes on. We have some new documents that have been dropped, and we're going to read them. One of them's pretty lengthy, and so the hearing isn't scheduled to start for a little bit. Let me pull this up, and I can we'll show you guys. So we have an additional 20 minutes and 19 seconds before it comes on. So I have it playing in the background. If noise comes on, then we'll obviously hear it. But I'll be going back and forth just to make sure once it does start that we're locked and loaded and ready to go, if you know what I mean. But beforehand, let's start off with a couple of documents that were signed and dropped. I'm going to start off with the one that's not as lengthy, and then we'll go into the more lengthy one. The first one that's not as lengthy is the state supplement response to requests for discovery regarding expert testimony. To the defendant, Bryan Christopher Kohberger, and counsel Ann Taylor, comes now the state in the above titled manner and submits the following supplemental response to requests for discovery regarding experts which the state may introduce at trial pursuant to Rule 702, 703, or 705 of the Idaho Rules of Evidence. I wish I was a little bit further on in my studies here for law or whatnot, because I honestly don't know what any of that is. You know, the Rule 702 through 705 minus 704. But a response to requests for discovery regarding experts. I'm assuming the state has a new expert that they want to testify, and are now passing over some information. Now, how is this going to go over with the judge who is looking at an order of continuance, and the state is now responding with this? But I don't know if that's actually what it is. I'm not a lawyer, and so my expertise isn't finely tuned in that regard. But to me, it sounds like they have a new witness. Let me know if that's what it sounds like to you guys, aka Chloe. Let me know what you think. If you've answered, please redo it. I didn't see it. All righty. It says here, it is anticipated the state may call Dr. Christian Westring, exhibits S1, S1A through B. The state respectfully submits the above and demonstrates that it has fully complied with its duty of discovery and disclosures regarding experts in accordance with Idaho criminal rule. Oh, I got it. Yes, I did get it. So they do want to bring in a new witness. Now, who is this witness? Professor Christian G. And I'm assuming this is him. I understand that there's a high possibility that it could be a different Christian Westring. So be in mind, this is the one that I could find that seems like he would be called as a witness. So Professor Christian Westring, director of PNW's Center for Crime Forensics and Security Analysis, is a forensic geneticist with more than 15 years of experience in forensic science. Through his passion for molecular biology and complex problem solving, he applied new innovations in the field of forensic genetics to benefit law enforcement investigations and public safety. He specializes in cold case investigations, applying novel scientific techniques for solving complex crimes. To me, it kind of sounds almost like maybe this is what they were trying to, maybe this is the witness that they're trying to bring in to explain the whole IGG mess. I know that they were, Dan Reed is being called to return. Oh, wow. So we might end up getting an answer there in the Reed case. I don't know if it could be a verdict or question. Let me know. Thank you. I haven't heard anything on that, if there was a verdict. I'm surprised there isn't one yet, given the questions that they had. I expected a verdict to come in like within an hour of the questions that they had the other day. I'm actually quite shocked it's gone this long. But let me know. We'll talk about it once it breaks here if we're not into the hearing there. All right, so let's continue this. In the laboratory, his primary research interests include the study of inhibitory compounds associated with gunshot residue and how they impact the biochemistry behind PCR-based DNA typing, probabilistic genotyping, and implications with complex DNA mixtures. All right, so that might be what it could be right here. Implications with complex DNA mixtures. This could be the answer to why, for instance, the fingernail DNA and or the small amount of DNA that was on the handrail between the first and second floor. This might be the witness that's going to give us the answer to why those weren't taken into consideration and if there was any issues with them. And so that's where I'm thinking that this is going to go at right here. Let's see. And the development of new and improved methods for bodily fluid identification. Oh, maybe. I don't know. Could be a couple of different things, I guess. But if I had to take a guess, my guess is going to be the implications with complex DNA mixtures right here. Thank you, Midwest. Member mod fan, thank you so much. You're amazing. Coming in with a 199 super sticker. Westring bridges his passion for science and education by integrating students into his research. Students actively participate in applied science research, providing hands-on experience for solving the real-world problems. To highlight their success, several of his students have presented their work at recognized international conferences. As an educator, his course integrate professional experience with his youth enthusiasm for teaching, preparing students for the demands of the public science workforce. All right. So, like I said, a couple of things that I might, because there's no, even Hitler mentioned there was nothing about a gun in this case. So when it says that he primarily works with gunshot residue and how they typing, probabilistic genotyping, some of that stuff is probably not going to be associated with this case, but the implication of complex DNA mixtures and the development of new and improved methods for bodily fluid identification, I think might be where we see this witness coming in for the defense, for the prosecution, to explain certain things that may end up needing to be explained. If, for instance, this DNA stuff gets allowed in, the fact that there was a known DNA underneath the fingernails of a victim and on a handrail on the first to second floor and on a glove outside, the defense might, or the jury might want to know, why wasn't it tested? Why didn't they look into those things? And maybe this is the witness that can answer those questions. Lady Stardust 2008 coming in with one gifted Drunk Turkey Show membership. Thank you so much. We appreciate you guys. You guys are awesome. So I want to say thank you so much. You guys are awesome. All right. Let me check on the nothing here. Quite a few people waiting, though. Not surprised. All right, so let's go to the next one. This one was the defendant's reply to the state's opposition to the defendant's motion to continue. So this might actually be something we're going to hear in court, something that we might hear today in this hearing as far as arguments go. So this might be a little bit of a preview of the defense's side of things. So it comes on to say, comes now Bryan Kohberger, and hereby submits his reply to the state's opposition to the defendant's motion to continue filed with the court on June 5th, 2025. The state's objection to Mr. Kohberger's motion invites irreversible error. Prosecutors have the ethical and legal obligation to seek justice over convictions. When the defense counsel requires a continuance to complete the constitutionally required mitigation investigation, the state has no legitimate interest in objecting for any conviction and or death sentence obtained under such circumstances would rest constitutionally defective foundation. All right. So basically what they're saying is they put in some information out there of some of the work that they've done for the mitigation phase. And we saw in the last document that the state, when they objected to the continuance, how they were able to list a few things. One of them being a car accident that Bryan Kohberger had when he was a child that may have caused trauma, and some other things that they broke down as far as, all right, you looked at these things into his life, and, these are the answers to your questions. You broke them down. You've already submitted this stuff. And what the defense is trying to say here is that, the state can't tell us how much we can look into, which is, I guess, kind of true to a certain extent. And that this is a death penalty case and that it's important, which all cases are important, but, they're really putting in an emphasis on the fact that, Bryan Kohberger could face the firing squad if he's found guilty and things like that. And so I get it, but at the same time, there is in Idaho a situation where victims' families' rights also matter. And so what do you call it? Those things also take some sort of precedent. I mean, obviously the right for a fair trial is there, but give me one second, guys. I apologize. I'm hearing a bunch of noise in my background. I'm gonna have to go check that out here in a second. Well, anyway, man, I completely forgot where I was at. I apologize, guys. Oh yeah, here. So there comes a certain time when you have to get it going. You have to do the trial. I mean, you can't have somebody just continually say, well, we're not ready. We're not ready. We're not ready. It's been 3 years. They've had their opportunity. The evidence has been displayed to them. A lot of their objections and their problems with discovery was because they had a misunderstanding. They, being the defense, had a misunderstanding on the time that the AT&T that held on to the advanced call timing records. That was a 7-day retaining period, and they assumed because they had 3,800 phones that they should have also had Bryan Kohberger's at the time, not realizing that there was only a 7-day retaining time period at that time, and Bryan Kohberger's name wasn't one that came on radar until well after that 7 days. I believe it was December 19th. And so, yeah, I just kind of wanted to explain that aspect of it. So a lot of their issues, and even Ann Taylor said in that one hearing when they were talking about it, where Judge Hippler called Cyray's a conspiracy theory, his theory as a conspiracy theory, you know, in that order, that, or in that court hearing, is where he kind of said, sorry guys, I got distracted again. I'm having a day for myself right now. Well, anyways, it was there where Judge said, oh gosh, can't forget, I completely slipped my mind. I'm sorry, guys. Let's see, the defense can trial they want. Yeah, no, I get you. But let's continue to read this. Let's see what else it says, and it'll probably come to me here in a minute. For when the state obtains convictions against a defendant who has been denied effective assistance from counsel, it is the state that unconstitutionally deprives the defendant of his liberty. Kohberger, with the court scheduling order, does not fulfill Mr. Kohberger's right to an effective assistance in counsel in a capital case. The state suggests that the counsel's prior compliance with the court scheduling order somehow weighs against the present request for continuance, but the defense counsel's adherence to deadlines demonstrates diligence and not finality. Compliance was a good faith effort to meet the court's expectations, not a concession that the defense investigation is complete. Which is basically what I have been saying, you know, here. Hold on one second. That's basically what I was just kind of saying right now, that the defense is saying, hey, we turned in everything, we obliged, but that doesn't mean that we're done. Well, at certain points, you have to be done. This isn't the very, I mean, there's a lot of evidence in there, but as they mentioned, a lot of it was irrelevant. A lot of it was just, what do you call it? Footage from times that aren't relevant to the case. You know, when you go out there and you obtain footage from a security camera, you may be only interested in about 5 to 10 minutes of that security footage, but you have like 2 days worth of footage. You have to enter in that 2 days worth of footage into evidence. And so that's kind of what it is. You know what I'm saying? So there's a lot of that in it. And here they're saying with the medical stuff and the mitigation stuff that they're not complete. But I mean, the state, in my opinion, pointed out quite a bit when it came to what it is that they have done that would have fulfilled those needs. So I think we're going to hear this in here in the court hearing right now. Let's see. What time does the hearing start? It starts in about 6 minutes, I believe. Okay. I think they're actually... All right, let's hit the live button. Let's turn this on. So that way, if they do start talking, we automatically hear it. So they are live now. Let me do that. And so they're live. They're just court hasn't begun yet. So I have it playing in the background. So once it starts to come on, we'll all be able to hear it. We won't miss a thing, like Aerosmith. All right, so let's continue this. The defense has now identified information and developments that make it clear additional time is necessary to meet the minimum standards of an effective assistance of counsel. So, okay, what have they identified? To fulfill the capital defense duties and Supreme Court case, the fact that the prior deadlines were met does not somehow negate the need for continuance, whereas the timeline is insufficient to complete the investigation and presentation of a constitutionally adequate penalty phase defense. Mr. Kohberger has the right, and I haven't read much of this. I only read to the part that we saw highlighted. So after that, this is all new to me too, guys. So Mr. Kohberger has been pending. Case has been pending for less than 2.5 years. That is a short duration compared to other capital cases. The state suggesting that the defense, but does that make a difference? Like, let's talk about that. Just because another case took longer or shorter, what does it have any difference on this case? In some cases you have some things that happen. In other cases, you don't. I don't understand this notion where, oh, well, this other death penalty case took a long time, or these other death penalty cases took the exact same amount of time. I'm sure the prosecution can point to some other death penalty cases where the defendant didn't waive their right for speedy trial, and they went to trial within X amount of months or a year, depending on where they're located, how long that has to be. You know what I'm saying? Verdict was in, then not read. I'm not sure. Let me see what I'm seeing on my Discord. So I know everybody's kind of tuning into the Karen Reed stuff. Let me see what's going on. Let us see. A lot of people are saying could be a question, could be a verdict. Could be, I don't know. Everybody's tuning in also on the Reed case. So if it breaks, I'll talk briefly about it. Verdict not in. Verdict was in, and they changed their minds. That's interesting. Well, anywho. So for over here, the time frame, I don't think you can look at other cases and try to determine, hey, this case is going too fast, or this case has gone too slow, based on a different case that is completely different. You know what I'm saying? I just don't see it. I don't. Let's see. The capital case is extraordinary, both in complex and media attention. Now, there's been some media attention in this case. Obviously, that's anybody who would try to say different would be a liar, obviously. So has there been a lot of media attention? Yes. But has there been media attention in other cases? I would reckon so. I mean, Karen Reed is a case right now that's gotten a lot of media attention. O.J. Simpson, Casey Anthony, these are all cases that outside of Karen Reed, because the verdict isn't in, but these other cases, O.J. Simpson, Casey Anthony, that had high publicity, didn't go in favor of the Commonwealth. Now, I'm sure there's been a lot of other ones that did go in favor of the prosecution or the state that were high profile. But what I'm trying to say is, just because it's a high profile crime doesn't mean that that you can't seat a jury that can make a decision based on the evidence presented in front of them. And I think that that's a high indication of that. Now, the longer we wait, I think the more information does come out. The DoorDash driver is somebody who just recently popped up, and it wasn't something that was out there for public consumption. It was supposed to be a DWI arrest, and during her conversation with law enforcement, she advised that one of the reasons why she's going through such a hard time is because she saw her husband lose his life right in front of her. And now she's also testifying that she was out there and saw Bryan Kohberger, saw him outside of the house, parked right next to him in some form or fashion. And that's now come out. Now we know there's a book. We know Amazon Prime is coming as well. I just don't see how you think that by prolonging it, less information is going to get out. I think more information is going to get out. I think the families are sick and tired of not being able to mourn their loved one in a manner that they want. And if that manner that they want to mourn their loved one is going out and talking to the public or talking to people, then let that be what it is. A lot of people mourn in different ways. I have 3 daughters. I'm supposed to have 4. My oldest daughter passed during birth. She was a stillborn. The way I coped through that was talking about her, and her mom was completely opposite. She didn't want to talk about it. She didn't want to do anything to do with it. And it's just 2 different people, coping through the same type of thing. And so, some people cope in those ways. Some people mourn in those ways. And I don't think it's right that you should bottleneck the victim's family members and what they can say, because out of fear of that it might make the person who's accused of taking their loved one away, it might make them look bad. Like, come on now. I mean, if he didn't do it, I get it. He's presumed innocent and stuff like that. But victim family members and trying to, quiet them or any of those type of things is just, it's, to me, it's unfathomable. And I just don't like the extent that the defense wants to go with a bunch of these things. They wanted to limit people talking about this case, limited the cameras. They didn't want you to see it. Don't want you to hear about it. Don't want you to read about it. Want you to talk to your friends about it. Don't want you to attend vigils. Don't want you to attend anything that would show light to the victims or show them in a good light, because it all would affect their client in a negative manner. I mean, if that's all it takes, if all it takes is for a victim's family member to talk about their loved one, I mean, to me, that's somewhat a bit of a sense of conscious guilt, don't you think? I mean, you know, he didn't do anything. Why does it make you feel guilty when people talk about him? You know what I'm saying? And so, and thank you guys. I appreciate that. It was a long time ago, and yeah, she'd be like 20 now. And so, but everybody, like I said, everybody copes differently, and I'm not a fan of this by any means. You know, this gag order stuff, you know, to a certain extent, I get it. You know, certain things should not be out there for public consumption. 100% agree. 100% agree. But trying to put a lid on so many other things is just, you know what I'm saying? I don't like it. All right. Recent Dateline episode and media leaks are uniquely prejudicial and distinct from ordinary media coverage. So let's see what this says. The state argument that the Dateline episode did not require continuance, that fact preceding the trial as scheduled, may actually avoid negative consequences from future publicity, which is kind of what I said right now, completely misses the point. Well, I think you also missed the point yourself. The defense is not asking for continuance based on the ordinary publicity that attends a high-profile criminal proceeding, such as coverage of court dates and public filings. This is something that's wholly different. The high-dramatized TV special, completely with its ominous music and narratives, first-person testimonial, false reports, and non-public information that was leaked in a violation of the court's non-dissemination order. Now, that's a big statement to say, because they're saying that was leaked in a violation of the court's non-dissemination order. I mean, maybe the selfies, some of the stuff that was there, but what did Dateline actually leak that we didn't know? Right? We knew he drove by there 23 times. We knew he purchased the K-bar knife and the knife sharpener and the knife sheath well before he moved out there to Pullman, Washington. We knew about that there was not I guess we didn't know that he was following, to a certain extent. You know what? I think a lot of people did know that he was following some of the victims and some of the victims' friends and family members. We didn't know which ones and which pictures he had on his phone, which, I'll be honest, those photos were blurred. You know, even the selfie ones didn't look accurate that he had taken. Now, what does a selfie of him wearing a hoodie mean? You know, in the end, how do you correlate him wearing a hoodie to he committed the crime? I don't see it. Now, I get what Dateline was trying to do when they said, all right, there was these Ted Bundy searches, and in these Ted Bundy searches, there was an image where on a thumbnail Ted Bundy had a sweater on, and he was wearing a sweater afterwards, and they're trying to correlate those two things together. But yeah, we already knew that. I mean, I don't see how that correlates to him committing the crime. Now, if they showed pictures of, you know, the crime scene, or if they showed pictures of the K-bar knife in his hand and all these other things, maybe that's something that I would be kind of like, whoa, that's really prejudiced against them. Now, I'm trying to think back, the other people who were talking about the hiking and all that other stuff, that's not part of the non-dissemination order. You know, all those other people that had this involvement with him, Nayoung Ko, she's not part of the non-dissemination order. Her friend ain't part of the non-dissemination order. So all that stuff, like, what violated the non-dissemination order? You know, yes, we saw the vehicle drive by, but we've seen still images of the vehicle driving by in court documents. And yes, we got to hear the thud and the barking on the camera and see the vehicle taking off at a high rate of speed. But we've already read that that's what happened. We've already read and understood what noises were out there. So to me, I mean, I get it. You know, it looks bad, but I think it looks bad not because it was one-sided or whatever. It's bad because this guy has a lot of evidence that he's going through. You know, and there's a lot of evidence against him, and his own actions were kind of weird. So let's see. It continues to go on. It says it was a choreographed narrative broadcast to millions of viewers and advertised to millions more. It aired nationally and promoted heavily across commercial breaks, streaming platforms, and social media, maximizing its visibility and impact. It was designed to provoke strong emotional reaction, which is exactly the influence that taints jury pool and risk depriving Mr. Kohberger on a fair trial. So that's the other thing too. Like, you know, you had somebody that was speaking whose daughter was supposed to be there that night and didn't come out. Is that part of that emotional stuff, you know, that they're talking about? Why can't they talk about their fear? Why can't they talk about what almost happened to them? Why can't they talk about what happened to their friends? I don't get it. I don't get it. I don't understand why, you know, it's not like they're pointing the finger at Bryan Kohberger. It's not like the lady that wasn't there that night. She's not saying, oh, you know, I wasn't there, so it was Bryan Kohberger. It's not what's happening. It's not what's said. Let me check to see if this thing is on. It is not live yet. Not live. Not yet, guys. Not yet. All right, Chloe says, my opinion, the jury submitted an incomplete verdict form. Not all counts had a decision sent back to deliberate. My best guess based on what I saw. Not fact, very unusual. I don't know. It's weird. It is weird, but it sounds like they might have it sounds like they might end up having a verdict here pretty soon. So we might have a decision soon. Does anyone believe this will be continued? I don't know. You know what? Let me put in a poll real quick. Let me do that. That's a good question. Will it be continued? As long as they do not discuss the possible testimony, can they discuss what they want? Correct. I mean, I would think so. You know. So what can they testify to though? Right? Like for the young lady who wasn't there that night, what can she testify to? What can she say? You know, she wasn't there. You know, now if she said, oh, I saw a white Elantra parked in, you know, back behind the house multiple times, maybe you got something there. But what can't she say? You know, now I do understand like some of the key witnesses, you know, and talking about their testimony 100%. But I'm talking about victims' family members and people that really don't know much about the case outside of what law enforcement and, you know, as put out there to the public and what has been discovered through our means. Let me start this poll real quick. Yeah.
All right, this is CR 0124316665, State v. Kohberger. On behalf of the state, we have Mr. Thompson and Mr. Horowitz. And on behalf of, when you should note the defendant is present with counsel, Ms. Taylor, Ms. Massoff, and Ms. Barlow. Or at least the public portion of today's hearing for the motion to continue the trial filed by the defense. So we'll start with that.
Good afternoon, Your Honor. Your Honor, our motion to continue has been filed and is necessary to protect Bryan Kohberger's rights under the United States Constitution and the Constitution of the State of Idaho. Specifically, a continuance is necessary to protect his due process rights, his rights to a fair trial, his rights to effective assistance of counsel, rights to confrontation, Mr. Kohberger's right to present a full defense, and if it should come to it, a fair sentencing hearing and to be free of cruel and unusual punishment. The record of this case spans 2.5 years, and it shows that this request does not come as a surprise. Looking through the history of this case shows that the defense has met challenges and difficulties along the way, but has been dedicated in meeting all of the deadlines. We have talked about the discovery issues in this courtroom before, and that in large part brings us to need a continuance. 68 terabytes of information is a huge amount of information. There have been 23 requests for additional discovery over the span of 2.5 years and 7 motions to compel. When I say that this doesn't come as a surprise, that this comes from the record, I would direct the court to look back to May of 2023 and June of 2023 and our second motion to compel. Included in that was what was known as Exhibit A from the defense, and that depicted how we were receiving discovery. So this is not a new issue. This is something that's been coming up for a long time. We were receiving discovery, but it was such that you would get a file that would say hundreds of photographs, hundreds of pages of reports, each having to be looked at individually to know what was there and then organized. This case has also faced unique issues, starting with the media coverage of this high-profile case, non-dissemination orders that were addressed in courts, and then the grand jury materials that we had to fight to get access to before we could properly challenge the grand jury indictment. We faced issues with discovery, particularly with the IGG materials. We spent a great deal of time trying to get access to those materials. Those were ultimately what we could get, was ultimately presented in a motion to suppress, and that's preserved should there be a conviction in this case. We faced venue issues in this case, culminating in the change of venue and bringing us to Ada County. At the first hearing in this courtroom, we discussed the discovery issues and not having read everything and being ready with a full investigation in this case. That was apparent through our motions to strike the death penalty, our motions to compel expert disclosures filed in September and December of 2024, and requests for more time to file our motions in limine that was granted in January of 2025. Throughout the course of the motions in limine and then a motion to strike death based on discovery issues in February and March of this year, the record is replete with notice that we are not prepared to go to trial in this case. The discovery is vast and we have not had a chance to review it all. That we met deadlines for experts shows our dedication to comply with court orders. It does not depict effective counsel ready to go to trial on this case. We would submit that it's the court's responsibility to assess this motion to continue with heightened due process that's required in death penalty cases. The death penalty case is different. That comes from Ford versus Wainwright at 477 U.S. 399 at 411. The court must be sensitive to safeguard every avenue of due process. The Idaho Supreme Court said the qualitative difference between death and other penalties calls for a greater degree of reliability when death is imposed, and that comes from State versus Creech, 105 Idaho, 362 at 383. Looking at all of the constitutional rights Mr. Kohberger has, effective assistance of counsel really becomes the crux of how all of these other rights are covered for Mr. Kohberger. An effective assistance of counsel applies both to the merits phase and the penalty phase of a death penalty case. The courts are guided and counsel is guided by the American Bar Association guidelines on capital cases. Wiggins versus Smith, 539 U.S. 510 at 524, said the ABA guidelines are guides to determine what is reasonable. And that's talking about reasonable performance by defense counsel in a capital case. The Ninth Circuit in Andrews versus Davis at 944 F3D 1092 at 1109 said relies on the ABA guidelines as the proper measure to test an attorney's investigation. In Idaho, our public defender statutes reference the ABA guidelines as applying to indigent defense. These apply to the full investigation of the merits phase and require us to raise all legal claims. They require us to perform a background on all witnesses that might be called, especially those being called by the state. That means that we have to review all discovery to be able to present a full defense for Mr. Kohberger. We cannot present what we are not aware of. I would note for the court that discovery has been ongoing. I received discovery just this week. It is discovery that I have not reviewed yet. Considering what's required at a penalty phase in a capital case, we're required to perform in a way that the jury can carry out their function
It's Wednesday.
of
Why not review it
individualized
already?
sentencing. That means that Mr. Kohberger's background has to be known and investigated and ready to present to the jurors. Evidence of his character has to be known and ready to present to the jurors, and his circumstances have to be known and ready to present to the jurors. That's addressed in the Woodson case and in the Lockett case. The jury must have the opportunity to consider all evidence that may weigh against the death penalty, and that means anything from his life history. It is the duty of the defense to find and investigate all mitigating information. We do have several experts that would be ready for the mitigation portion of the case should the case reach that phase, and they rely on understanding family history and Mr. Kohberger's own history. They can only understand what they've been presented, and the investigation to fully evaluate needs to be thorough. That means that records have to be collected. That means that interviews, collateral interviews have to be done, and those have not all been completed. And it's not because of a lack of diligence in this case. Further, when things that are noted as red flags arise, those things must be investigated. Red flags aren't fanciful ideas of what else could we do in this case. They're real things that come up in the course of the investigation, and whether or not they're important to mitigation and presentation for a jury's consideration requires time to investigate and collect records. Documentation is very important. The court's aware that red flags have come up and they require further investigation. Those are issues that may mean a lot to the experts that would be ready to testify, but they can't be presented until there's a full investigation. They are things that might change the course of the evaluation or might require us to have an additional expert to help explain certain circumstances. And that's important for the individualized sentencing that's required by the Constitution. Your Honor, there have been numerous challenges with gathering records and interviewing collateral witnesses. I know the court is aware of some of those particular issues. I'm not going to highlight them now, but it's imperative that we be able to collect records and conduct interviews from other family members besides just Mr. Kohberger and his parents. And it's also imperative that his history be complete with educational records, medical records, and those things are still being done to this day. The other reason that a continuance is appropriate in this case is based on the media coverage, the Dateline issue that has been talked about in this courtroom before, and what's yet to come. The Dateline episode wasn't just a one-time deal back in May. That continues to be talked about. Everything that happens in this case continues to be talked about, and this court has a duty, a responsibility to make sure that Mr. Kohberger receives a fair trial. That comes from Shepard versus Maxwell, 384 U.S. 333. And a continuance may be the way that the court can best protect Mr. Kohberger. That comes from Patton versus Yount, 467 U.S. 1025. In addition to what is going on with what happened with the Dateline episode, that's not all. There's a book set to be released just a few weeks from now, to be followed by a docuseries on Amazon Prime. There's a claim that there's inside sources that provide information in this case. At the very least, the moment we start attempting to select a jury in this case, those things are going to be on everybody's TV, everybody's social media feed, and some of the very witnesses that will be expected to testify will be taking part in the docuseries, at least, and maybe noted in the book. That is, in and of itself, an exceptional reason for us to have a continuance to let those things play out for a while. I would also note, Your Honor, that jury selection is going to be particularly challenged and will need a great deal of time based on what's happened in the media and continues to happen. Your Honor, our request is for a continuance in this matter to allow us to be effective and perform our constitutional duty for Mr. Kohberger, to protect his constitutional rights, to make sure that we have fully investigated all mitigating circumstances so the jury, if it comes to it, can perform their individualized sentencing, judgment, and function, and to allow some space between what's recently happened in the media. Thank you.
Claims of inside sources doesn't mean that there are. And the other thing is, it sounds to me like she planned this with all those discovery things that she was talking about. Much of it being the call records, remember? This is a new prosecutor. I'm excited to hear what he has to say and how he comes off.
Thank you, Your Honor. I will, I think, address Ms. Taylor's arguments sort of in the reverse order in which she raised the issues that she raised. I want to begin, though, by bringing us and the court back to what the standard is for this motion to continue, as opposed to what might happen after a conviction with respect to ineffective assistance of counsel. Right now, the standard is whether denying a continuance would violate the defendant's rights by causing unfair prejudice. And that is an objective standard that the court has, and the court has discretion on all motions to continue, including a motion to continue in a case such as this that involves the death penalty. What the defendant and counsel are asking the court to do is delay this trial because of their subjective, prospective beliefs about how an ineffective assistance of counsel evaluation would happen by an appeals court if there is a conviction. What this court should do is use its discretion and look at the objective record. The record supports denying the motion based on what the defense has been doing, continues to do, and will continue to do through the mitigation phase until the penalty phase, including presenting mitigation evidence that the jury will ultimately decide about if there is a conviction. The lens that the court should look at is well stated, through which the court should look at this motion is well stated in some Idaho case law and others. And if I can turn on the Elmo, do I need to hit this button, Your Honor?
Clerk needs to switch it over.
Okay, thank you. So these are cases that we cited in our brief, and I wanted to start my discussion with them. I'll read the top case, which is an Idaho Supreme Court case, evaluating whether counsel was effective in a death penalty case. Counsel was not required to investigate defendant's entire life in order to objectively and reasonably present mitigation evidence. And then I like the way that the Seventh Circuit sort of rephrased the same principle by saying, I won't read the entire quote, Your Honor, but a scorch the earth strategy is not required. We're in a standard of reasonableness. And the record that is before the court, and I'll acknowledge we have not seen what specifics, if any, the defense has put forward in its ex parte filing.
It's kind of hard for you, I recognize.
It does, but we have not seen specifics. I did not hear any specifics from counsel just now about these witnesses need to be contacted, these records need to be obtained. And then the court, I think, mentioned at prior hearing we had when this was motion to continue was first raised, that the court would be looking at what admissible evidence the defense needs to obtain and what strategies would actually be used to fruitfully obtain that evidence. And we don't have anything
I
specific
like that response.
that we can respond to about that. So I'm at a bit of a disadvantage, Your Honor, but I think the record that we do have shows that the court can use its discretion to deny this motion to continue. What we did in our response brief, Your Honor, was to cite the fact that the defense has identified 55 defense witnesses for mitigation, and I think one was recently added, so we're up to 56, 132 exhibits to use at the mitigation phase. And with respect to the ABA standards, we're not saying the court should completely ignore them, but what we are saying is that the court should look at them for what they are, which is a retrospective tool for appellate courts to look at the performance of counsel after a conviction, not some checklist that needs to be religiously adhered to in order to actually get to trial. Even if the court were to rely on them heavily, though, the charts that we put together show that for each of the ABA guidelines categories that the defense has raised, we have seen evidence in the record that shows that they have witnesses to talk about those issues and they have discovery on those issues themselves. Now, defense has called that superficial, but we would ask the court to look at the tables and look at the witnesses that we've been able to identify for each category and also the discovery in the record. So, Your Honor, again, we think that given legal standards here on a motion to continue, given the court's discretion, given that we are in a world where the court needs to satisfy itself that defense has done a reasonable job to prepare for trial, excuse me, to prepare for trial, there is no basis for a motion to continue. Now, let me turn to some of the specific arguments, and I can take this down, Your Honor, that Ms. Taylor raised. With respect to the media coverage, we acknowledge, as the court has, that will pose challenges for jury selection. The issue, though, is not whether there is a lot of publicity. We know there's going to be a lot of publicity regardless of when this trial happens. As Ms. Taylor said, people will continue to talk about this case. The issue is whether the court,
the likes of guys,
using the procedures it has established, or maybe even modifying them as the court wants to, can seat a panel of impartial jurors. The Supreme Court of Idaho has found that despite widespread publicity, even on the day of jury selection, that is possible. That is possible in this case, despite the challenges. The other thing I would mention with respect to the publicity is that it puts us at the whim of the media. Every time there's a breaking story, every time there's a new book or a new documentary, are we going to continue the trial indefinitely? And that seems to be the danger in what the defense is asking for. We call it a perpetual continuance, and we haven't seen a proposal about when this trial could take place if there's a continuance. What seems to be the strategy here is just to delay. And that leads me to, I think, the other point that Ms. Taylor raised, which was to say that, this shouldn't be a surprise. It is a surprise to us that a motion to continue was made so late in the game, after, by the way, the trial date was used to oppose an extension that we filed for with respect to our mental health expert. At that point, the defense said, we can't possibly go down this road or give the government the state what it wants because of the trial date. Once that issue is resolved, then we get a motion to continue. So I think what we have seen from the defense is that they tried to use the mass amount of discovery to remove the death penalty from the table. When that failed, now we have a motion to continue. So I do think timing is relevant here. Again, and it's not just that the defense waited so long, it's that we now have a very substantial record on which the court can deny this motion based on everything that's been put in front of the state and the court. In terms of the mitigation investigation, Your Honor, we believed but did not have confirmation that the defense had a mitigation specialist until the reply brief on this motion alluded to an affidavit that mitigation specialist submitted. So I don't know what that says. I don't know what the mitigation specialist has said, but the fact that there is a mitigation specialist, apart from the 3 attorneys and 2 investigators that are part of the defense team, that person has one role, as I understand it, which is to prepare for the penalty phase if we get there. And that person, that specialist, has still time to continue doing whatever work they told the court they need to do. Your Honor, again, I would try to get back to the record and ask the court to look at the objective record when evaluating this motion. 55 mitigation witnesses, over 130 exhibits, a very robust team on the defense side, which includes their retained experts. Ms. Taylor, and in the briefing, really honed in on this idea of a social life history for the defendant. I don't know if the court has read the expert reports of the defendant's forensic psychiatrist and then the licensed psychologist. I won't discuss the details in open court, but our position is that both of those specialists, well-trained, very experienced specialists, conducted significant, fulsome life history investigations. They weren't just looking at bare records. They were talking to people from the defendant's past, from his present, his family, and developed parallel life histories. And in their reports, as I read them, no red flags that needed further investigation were noted. Nothing about those reports appeared to be incomplete. And the experts didn't say, we are unable to reach the conclusions we need to reach for lack of investigation. So I think that is sort of proof in the pudding. We have a life history for the defendant. The defense has amassed significant materials. And I thought we were going to be solely talking about the mitigation case that still needs to be developed. That is not a basis for a continuance. And to the extent there are ongoing discovery from the state that Ms. Taylor alluded to, I can represent that most of what was just turned over was our investigators speaking with witnesses that the defense has disclosed. So that's the nature of that discovery, is us responding to discovery from the defense. And that will continue, of course, to occur as we lead up to trial and witnesses make statements that we need to disclose to the defense. So with that, Your Honor, I would again rest on the case law holding that a scorched the earth investigation is not what's required. And on the record before the court should exercise its discretion to deny the motion. If the court has any questions, I'm happy to answer those. Otherwise, we would submit on the record before the court.
Thank you.
Thank you.
The verdict in on Karen Reed case is not guilty on everything except OUI, guys. For those that were waiting on that. Crazy situation. I know a little bit about that case, the behind the scenes stuff.
If the new discovery
Crazy.
is the state's contact of witnesses we've listed, the state knows that there are mitigation witnesses that we've listed because we had to disclose them, but there are people that have refused to speak with us. That presents a challenge in the case. A lot of the witnesses that refused to speak with us have to do with records, medical records of Bryan Kohberger, past treatment records of Bryan Kohberger. Those are important things that
Subpoena them.
the gravity of what they have to say can't be known to our experts until we have the opportunity to fully understand those things. And we continue to work on access to witnesses and access to additional information. Your Honor, I want to touch on just a couple of points. One, when the court considers a continuance and considers whether Bryan Kohberger's rights are violated, his right to a fair trial, his right to confront witnesses and evidence against him, his right to present a full defense, and his right to effective assistance of counsel are implicated and laid out in our motion to continue. The ABA guidelines require us to do a full investigation. It's not going scorched earth to understand Bryan Kohberger's full life history. These are things that are required. And we've done everything that we can. We have had a mitigation expert on the case. This is 2.5 years into a case, and the average for capital cases is 3.5 years.
In federal court.
In federal court.
Moves at a snail's pace in its best day.
Yep.
In regular cases.
I'm not a practitioner in federal court, so I don't have any basis to talk to the court about that. But what I can tell
This is going to get denied, guys.
is that a capital case where we have a client and we need to investigate both the merits phase and a penalty phase at the same time takes time. In any case, it takes time to do that. In this case, with the high profile nature and having people decline to talk to us presents a whole set of challenges that we have to find a way to work through. As the court knows, a lot of mitigation information is very sensitive information. It takes some time to be able to get people to talk about things. Realities exist too. Not all of the family members are in the same place. So there's travel that's required. All of those things take time to do in a case
They've
like
had
this.
2 years, over 2
2.5
years.
years is excessively fast to put all of that together. There was no delay in having a mitigation expert on board. There was no delay in getting investigators to work on the case. And as soon as issues became apparent, Mr. Kohberger's team did not delay in getting experts to help us understand specific areas of the case. Looking
They got
over the
conspiracy
entire record,
theories.
the court can see that the defense team has been diligent about discovery, about motion practice, about litigating issues in the case. There just still is a lot left to do. There is still a lot left that is not known. And Mr. Kohberger has a right to go to trial with prepared counsel that have conducted a full investigation in both phases of the case. When you have a certain amount of information and there's this other stuff that's out there, that's a red flag, that's real, that you need to investigate, your experts can only do what's here, what's been investigated, what's been produced for them to assess. This whole other area, that land between the red flags and the investigation, that's an unknown area. That's where there's ineffective assistance of counsel. That's where there's not a fair trial. That's where there's not an individualized sentencing proceeding. And it's that area that requires a continuance in this case.
Doug, I was saying, it seems like they were preparing to do this delay tactic a long time ago. You know, she said it was no surprise ever since the first one of those
I'll take
discovery.
the matter under advisement and get an opinion out in short order.
I think he already has his idea answered.
In the
though.
meantime, I fully encourage everyone to continue as if the trial is going to take place when it is scheduled for. Again, I reserve the right to write the decision that I come to, but as of now, I would tell you that it's likely you're going to trial on the date indicated.
Boom. Hammer dropped.
All right. Is there any other matters that we need to take up in the public session before we break to go to the private session?
Nothing further in the public session, Your Honor.
No, Your Honor, I don't believe so.
All right. We'll take a 10-minute break while the bailiffs clear the courtroom and we set up for the private session. All rise, please.
All right, guys. Well, that's what. Just expect for it not to be changed. I've been saying it for a while. A lot of their arguments have been the same arguments that they have had. They being the defense. This has been something that has been continual. This is why I really like Judge Hippler, man. I think he's an excellent judge. He's fair. He's honest. He's straightforward. You know, he basically told them they were looking at court proceedings that are in the federal court that last 3.5 years, and you know, his response was accurate. You know, those are you know, at a snail's pace even on the regular court hearings. And so he understands the difference between a state case and a federal case, and it's time to move on. It's time to get this thing going. Now, I had a question, and let me see if I got an answer real quick. So because they said that they're having a hard time getting people to talk about his medical records. So I asked, and this is depending on what type of medical records, some traditional medical records, the defendant can sign off on release, which negates for subpoena. Sometimes subpoena is needed. I feel like she's talking about some obscure records that aren't available in traditional sense. Possibly. I mean, maybe from the school or something of that nature, if they were to do something that maybe they don't have any records anymore, you know, something when he was a young child, maybe those records got expunged, and the only person that can talk to or about those records are these doctors who don't want to get involved in this case. I mean, you know, I would like to believe most people don't want to help out somebody who's, and again, he's alleged, he's accused of committing a crime. He is innocent until proven guilty. But I think there's a significant amount of evidence out there that kind of point in the direction of his guilt, that if you, you know, somebody goes out there, they can be seen under a lot of scrutiny, which is shouldn't be the way it is. I mean, I don't think that's going to be the case. I think if somebody were to go out there and testify on behalf of Bryan Kohberger, as far as the medical records go, or a doctor who saw him as a child, I don't think they would get harassed. The other side, on the other case, you know, look what's going on with the DoorDasher, which I did want to bring up a point real quick, that when it comes to the DoorDasher, you know, a lot of people were pointing out that in a court filing that it is indicated that Dylan is the only person alive to have seen the intruder. You know, a lot of people have confused that as she's the only person alive to have seen the killer. No, it says intruder. Those were the terms that it was using. I'll see if I can find the document here in a minute, but it says intruder. Now, if the DoorDasher did park in an area where, whether it was right next to Bryan Kohberger or if Kohberger pulled up right next to her, he wasn't inside the house. He was inside his vehicle, from what I understand. So he wouldn't be an intruder at that point. And so just kind of those things that kind of point that I noticed that some folks were trying to say in the comment section. I pointed it out. Let me see if I can actually find the document so I can show you guys. I got to go up a little bit. I know it was in my Discord, which there are links in the for the members. I know we have a few new members, so we do have a couple link. We have a link in there to get into the Discord. You can be part of the conversation. It's only for members. Once your membership does run out, we do go through there and purge out members who are no longer members. So if you want to stay in there, you got to stay a member. But yeah, earlier I had asked that question and I can't find where it was sent to me at. But it was the term intruder. Let's see. It was the term intruder, not murderer, killer, or anything like that. So they used the term intruder. So I would say that the DoorDasher seeing somebody outside still would be still would constitute as a possible witness of somebody outside, not somebody inside the house, not as somebody as an intruder per se. I hope that makes sense. And I've noticed some people have been trying to piece together that maybe perhaps the DoorDasher was the person that ended up committing this crime. It's wild what people will say. It's wild what people will say. Messaged me. Yes, it was on Messenger. I knew it was on Messenger, Chloe. I just can't find it for the life of me. There it is, page 8. Okay, so this one is, let me pull this down real quick. Hey, let me go back to that. Let's go back to the poll. Me and the poll that I had going on. We had all right, so the poll is over. I have so many people. I think it said like 70% or 68% said, there it is. 67% said no, that the trial will be continued. No. 32% said it will be continued. No decision yet, but it does seem that it most likely will be continued. All right, so this one is, and this one goes back to 4/18/25. And this one is order of defendant's motion in limine reference witness identification. All right, so I got it here. Let me pull this up. All right, page 8. All right, so there is no basis under RIE 43 to exclude DM's testimony. It says DM's testimony about bushy eyebrows is highly relevant in this case. DM is the only eyewitness to the intruder responsible for the homicides. So it says intruder. Doesn't say to the killer responsible for the homicides, to the murderer, to the, it says to the intruder. So, if he was outside in his car, can he be classified as an intruder when the DoorDasher saw him? I don't think so. I don't think so. So, I think that's just a matter of words, so to speak. I would to be like, all right, it said there that the only person to have seen, the killer that night would have been Dylan, but it says the intruder responsible. So there it is. There it is. Is this the one that also talks about Murphy? No, I guess not. Because it was Dylan's testimony where she says that at one point that she thought that she heard Xana going upstairs with Murphy, which is why I think, based on that statement alone, is why I think Kaylee was the target. It sounds like, if you look at the layout of the house, the first door you would have opened would have been Kaylee's bedroom if you walked up to the third floor. Now, I understand that Maddie's bedroom is the one that you can see. But if Xana's walking up the stairs with Murphy, that means that Murphy would have had to have run downstairs to go into her room. To me, that sounds like Murphy was what alerted Xana of something. So Murphy was a young animal at the time. He was a young dog. He was still a puppy. I highly doubt that Kaylee would just let him roam around when she was, throughout the middle of the night. You'd wake up and find messes all over the place if you did that. What do we know? We know that the intruder left the back sliding glass door open the entire time that the crime had occurred. Why do we know that, or how do we know that? Because the audio from 50 feet away from Xana's bedroom captured that. So during the altercation with Xana, that audio is the same time that you can hear a dog barking and that altercation at the exact same time. So that tells us that the only logical explanation is that the back sliding glass door was left open. So we know that Xana's room was open. We know that, from what I understand, Kaylee and Maddie's room was left open. So from what we can deduce is the fact that the MO or the motive of the killer. Now, this doesn't have to be, for those that are pro-burgers in here saying, oh, no, you're wrong. This isn't pointing out that this is Bryan Kohberger. This is whoever the intruder is. So whoever the intruder is, I'm going to call him Bryan Kohberger because he's the alleged. But for Murphy to go downstairs and alert Xana while there's something going on in Kaylee's room, Bryan Kohberger would have had to have opened that door first. It doesn't make any sense that he goes into Maddie's room and then goes into Kaylee's room, opens the door for Kaylee's room. Because remember, the door was left open also there. We know that because of the dash cam footage that the defense had brought up in documents stating that Kaylee's door was also left open and Murphy was inside without any blood. And they thought that that was suspicious, that he didn't have any blood or anything, that he didn't go into Maddie's room. So it sounds like whoever committed this crime likes to leave doors open. You know, so to me, it makes more sense that he went into Kaylee's room first, left the door open, and that's how Murphy gets down, goes downstairs and alerts Xana, who goes upstairs and, you know, is confronted with what she sees, or hears something, turns around to go alert Ethan that somebody's in the house, and you know, that's when she's confronted down that hallway, or as she's going down the hallway back to her bedroom, she's probably caught from behind or something of that nature by Bryan Kohberger, allegedly. Because it doesn't make any sense that he goes in there and he does what he does in Maddie's room with Kaylee, and then goes into Kaylee's room. Dog gets out. Like the series of events don't make any sense that way. So to me, it's either the door was always open for him to go down there and alert Xana, or the intruder opened that door first, then went to Maddie's room. Let me know what you guys think in the comment section and in the chat. All right, so I want to say thank you to everybody again one more time that has become a new member or gifted membership. You guys are amazing. Thank you, TCF. You guys are awesome. I appreciate every one of you. What did you guys think about the, I forgot to put this up there. What did you guys think about the hearing today? I thought it was pretty straightforward. Is court live now? No. Well, court is going to be going live, but it's going to be the sealed portion. Right now, they're talking about alternate perpetrators. They will be discussing, you know, if they're going to allow Ann Taylor to go down that route. By all indications, based on the first portion of today's hearing, it sounds like the continuance will be denied. It sounds like it's going to be denied. He said anticipate it on being, you know, on August 11th, and in the end, he said as of now he's leaning towards denying it. So, pretty explosive hearing. I know some people were asking if the G's were in the house, and they were not. They were told that this hearing wouldn't be very long, so they didn't make the trip. They're watching it on YouTube as well. So I know a lot of people were concerned. You know, they saw some people in there. So no, they weren't there for this one. They were aware it wasn't going to be a very long hearing. So, you know, they'll make those decisions. It's a long drive for them, or a flight for, you know, just to come in for about an hour on something that, you know, obviously nobody knew what the decision was until the judge made his decision at the end. But, you know, outside of that, you know, you only knew so much. Now, I think that there was a lot of signs here that were going to kind of tell us that this was going to be the outcome. You know, she really didn't give any explanation, she being Ann Taylor, any deadlines, any ideas of when she would complete her work, what exactly she's completing, what she's exactly doing that might take a long time, how long she expects it to take, when they should continue the court order, when the continuance should end and when it should continue. To me, you know, when she came out and said, you know, we've had multiple discovery, you know, requests and things of that nature, a lot of that was the call advanced timing records. You know, Ann Taylor said that in open court, saying that much of their argument when it comes to the advanced timing records was that, or their argument about discovery was the advanced timing records, which was something that was a mistake on their own. That at the time I took it as a mistake on their own. Now I wonder if it was deliberately done, you know, in efforts to show that they've done so many discovery requests, et cetera, that they now have some sort of leg to stand on when it comes to a continuance. Because to me, it sounds like they've been planning this continuance or this delay tactic to delay as long as possible from a very long time ago. And so, thank you, Heather. I appreciate that. When will we find out who the alternative perp is? I don't think we are. I'll be honest with you. Everything being sealed on it, I think they're going to deny that motion as well. Just my opinion. If I had to do a prediction, I'd say that it's going to be denied. just like the motion to continue. And Bryan Kohberger will be able to face his accusers come August 11th in trial. And we'll see how that goes down. Now, right now, they're doing a secret hearing. It's very quiet, hush hush. It's on the alternative perp. And my guess is that Hitler's going to make a decision today after that hearing on both motions. And my guess is that we'll find out for sure one way or the other here pretty soon, whether it be tonight or tomorrow. You know, I'll be honest with you. I've noticed that the court here likes to release things Friday afternoon, right at the end. And so I would expect that would probably be the latest. If not today, tomorrow, the latest would be Friday. I'm assuming that the decision probably comes in before that, but the response to us, or to let us know from the court to the public ear, might be until Friday. And so that's where I'm at on that. Let me see if I have any more questions or comments before we call this one a show. Thank you again, TCF. Let's see. Agree. Yeah. Well, guys, this one's going to be an interesting hearing. This is going to be an interesting trial come August 11th. I think it's going to be for sure on August 11th. And by interesting, I mean I think we're going to find out a lot more evidence than what we've been told. I don't think there's going to be any plot twist or anything that pops up that's like, oh no, you know, this happened, or make you go, I don't even think they're going to find anything when it comes to the leak stuff. You know, when it comes to the leak stuff, like I mentioned, well, one, who's to say, and let me put it this way. When it comes to the leak stuff, I think timing makes a big difference. I think who it is makes a difference, where they're located. If it's a law enforcement officer, like a police officer in Moscow or you know, in Moscow, then I think that they probably figure out who it is pretty quickly. But if it's like a federal agent in Washington, outside of Idaho, that might be a different story. You know what I'm saying? That might be a different story to be able to figure out who that person is. I'm not saying that's the case. I'm not saying that the leaker is a federal agent out of Washington, but I'm just saying that you might have issues when it comes to agencies that work with the federal government and or people that may have talked outside of the jurisdiction of Latah County and or the state of Idaho. So there's a good possibility they may not even find out who that was, you know, but we'll see. All righty, guys. I'll be back on probably as soon as there's a decision on this. If there's a decision today, I'll be back on tonight. If there's a decision tomorrow, I'll be on tomorrow. Regardless, I'll probably be on tomorrow anyways. Talk about some true crime stuff. And Friday, if the decision is then obviously that's when we'll go live about that decision. If not, I plan on doing something a little bit for the What the Freak Fridays, the WTFs that we do. See, so I got some ideas about this weekend's or this Fridays. But you guys have a safe night, safe day. It was good talking to you guys. Trial ended up going in my opinion, in the favor of the state. I think this trial is going to be pushed forward. It's going to happen August. Well, jury, you know, they're going to go for the jury trial portion is going to be on August 4th. And I fully anticipate that this trial is going to start August 11th. Call your travel agents, get everything in line if you're going to be out there. I know that there's been times where people have made plans to go out to a certain place for specific hearings, and there was a motion to continue or a motion to, completely change locations, those type of things. And so I think this time it's set in stone, guys. I think we're going to be able to, there's going to be another trial at the end of this year, and it's going to be the Bryan Kohberger trial. Until next time, guys, you have a safe night. We'll see y'all later. Peace.
But it's too late now. I remember you and me, and how careless we could be.
All day and all night, we'd stay up, it felt so right. We were so young, we were so dumb. We would get drunk and then hook up. We were okay, we were alright, staying awake till the sunrise. We were in love, couldn't stop us, like a good drug, never enough.
We hook up in my car, driving so far, play your guitar, you'd show me your art, let down our guards, think with our hearts, stare at the stars, we were never apart. Drinking too young, way too much fun, out in the sun, hoping when he's gone. Took you to prom, dance to our song, dance all night long till the lights come on. Late now, I remember everything, and how careless we could be, and how careless we could be.